If you are waiting for a US asylum interview, pull your file out today. This is not a scare headline. The rule has already changed, and it is already in force. Social feeds are full of extremes. Every interview cancelled, or one form and you are deported. Do not let the title scare you first. We will walk the official text, line by line. Especially if you filed years ago and are still waiting for an interview, stay with this. The rule is not only about new filings. Pending cases can fall inside its reach too. On July 27th, the Federal Register published this interim final rule. It took effect July 28th. File the number 2026-15190. DHS and USCIS issued matching explanations the same day. In one sentence, USCIS may refer some affirmative asylum cases to an immigration judge without first holding an asylum interview. The key word is may, not must, for every case. This is not a draft for comment first. It takes effect first, then it accepts comments. You can still comment through September 28th, but enforcement does not wait for the comment period to end. That is different from many work permit rules people feared earlier, which often sought comment before a final rule. Here, execution comes first. Whether they listen later is still their call. To understand what this rule cuts, start with the path many applicants assumed. A large share of people still waiting are sitting on that old default path. Affirmative asylum means you are not yet in removal proceedings. You file Form I-589 with USCIS. For many people, that was step one. In practice for years, an asylum officer interview almost always came first. The office setting is less adversarial. You could fix a timeline, explain a blank, or clear a translation issue face-to-face. If the case was not granted, it might move to immigration court, where a judge hears it again in removal proceedings. Many people treated that as two natural chances: office first, court second. Because that office gate existed, many treated I-589 like a queue ticket. File first, fix details at interview. After this rule, that habit is the riskiest move on the board. What the rule moves is that middle link. It does not erase asylum. It changes the default path for some cases. From you will meet someone first, to you may be sent forward on paper alone. Officers may now review the application, records, and background checks you already filed. Skip the interview and push the case into immigration court. The next notice may be a referral, not an interview letter. Do not hear this, as every interview is cancelled. If USCIS will grant or deny asylum, the rule still requires an interview. What can be skipped is the default pre-referral meeting for some cases. That distinction matters more than memorizing the docket number. The screening gate is moving earlier. Where you once planned to explain at interview the story, dates, and evidence in the first file may now decide whether the next stop is the asylum office or court. The official text makes 4 finer changes. Titles are not enough. These 4 lines decide how you prepare the written record. First, clear authority to refer without an interview. Again, may, not always. USCIS has discretion, not an autopilot. Stop asking, will everyone be referred? Ask whether your file looks referable on paper. Second, language that sounded like an interview right is stripped out. Scheduling is more firmly in the agency's hands. Interview looks less like a right and more like an appointment they control. Third, referral notices still need reasons, but not a full credibility write-up every time. Lower writing burden means faster referrals. The thinner their paperwork, the more your written file has to carry the first gate. Fourth, when discretion already points against a grant, officers may make that call without finishing every eligibility step first. That saves their process time. Discretion used to be easy to ignore. Expect to see it more. Together, the bar to refer is lower, and the chance to rescue a thin file by talking in person is smaller. The written record is now the first battlefield. How big is this? Ignore rumour numbers like 40,000 or 400,000 floating free. Use the figures DHS put in the Federal Register. Every percentage needs a denominator, or the internet is just arguing past itself. At the end of fiscal year 2025, the affirmative asylum backlog reached 1,434,100, 45 cases. That is the affirmative queue, not every immigration court case nationwide. Wrong denominator. Wrong conclusion. About 444,724 of those were filed more than a year after entry or had a blank entry date. The document says that is roughly 31% of the backlog. Some outlets said 40,000, off by a full order of magnitude. 444,000 is not a list of cases already referred. It is a potential impact ceiling, but it shows this is not only about future filings. People who waited years can sit inside that pool. For future filings, they also estimate about 132,000 cases a year that may hit bars or similar grounds and move without interview. That is an annualized estimate, not a daily quota. Denominator again, these figures are affirmative asylum. The register itself notes early referrals may increase immigration court workload. Sometimes backlog moves. It does not vanish. Waiting less at USCIS does not mean the whole case ends sooner. Shifting the queue to court often means a harder forum, not an automatic win. Who is more likely to skip the interview? Check the risk types. Do not panic yourself sleepless, and do not comfort yourself that this is only about other people. Matching risk is for preparation, not self-conviction. Start with status structure. Someone who entered without stable, lawful status, and someone who still holds a visa or status that can keep them here, will feel very different paths. Do not paste another person's story onto your file. Crossing is not a legal category. People who arrived via the border can sit on at least 3 different tracks. Do not mix them when you assess risk. Track 1. You were processed at entry, got a notice to appear, and the case is already in immigration court. That is defensive asylum. This no interview referral rule does not remove an office interview you never had. Indirect impact is still real. Cases that used to sit at USCIS may pour into court, and dockets get tighter. You may not be the one referred under this rule, but you can still be squeezed into a longer wait. Track 2. You were not placed in removal. Then you filed affirmative asylum with USCIS. This rule is aimed at you. Over a year since entry with a weak or missing exception is the highest paper risk. Track 3. Entry through a port appointment or humanitarian parole, then an affirmative, I-589, that can still be the affirmative path. Do not confuse parole with a permanent status. Align the path to your own papers. Policy explainers also map 4 official impact buckets: 1-year filing barriers, bars to asylum, negative discretion, and claims that fail as a legal matter. That tracks the Federal Register framework. The notice is blunt. Filing asylum does not guarantee you will see an asylum officer. The burden is on the applicant. USCIS has no duty to send a request for evidence in every case first. Most common type 1, filed more than a year after entry, without a clear changed circumstances or extraordinary circumstances explanation, including why you filed within a reasonable time after the exception arose. The 1-year bar is a hard threshold this round. Late filing is not automatic death of the claim, but you must prove an exception and explain the delay. Hoping to fix the story at interview is far riskier now. If the exception is not in the file looks like there is no exception. Reasonable time matters, not a throwaway line that you only recently learned asylum existed. Connect when the change happened, when you learned of it, and why you filed soon after. A line a reader can follow. Type 2, the form says, "See personal statement," but no statement is attached. Many agencies and mills filed that way. Acceptance years ago is not safety today. Empty shells are common in old cases. Open that page now. This is not rare. For a few years it was a common filing style. If your case is old, pull the original form and check for a hollow cross-reference. Finding that one page beats watching 10 more videos. Type 3, the claim is too thin. You fear return, but not who harmed you. Why or how it ties to a protected ground. Economic hardship or family conflict often cannot carry asylum elements. Asylum is not the 4 words I'm afraid to go back. Name the actor, the protected ground, the timeline, whether the government protects you, and internal relocation, missing elements. Long writing will not save you. Type 4, an old case never updated. You filed thin, then waited years for an interview letter while the file stayed thin. An officer, reading only paper, may decide there is no reason to call you in. Waiting itself is a risk. Type 5, criminal records, internal contradictions or security issues. Officers may refer first and skip the office conversation. That is not a moral lecture. It is a path the rule allows. The reverse also matters. If you still have lawful status to remain, the framework more often points to a denial decision than automatic placement and removal. An interview or RFE may still happen, but an RFE is not guaranteed for everyone. Contradictions hurt. Passport, entry history, old visa forms, I-589, and your statement. If dates or identity stories conflict, an officer does not need to meet you to see the break. Many people treat I-589 as a queue ticket. File first, detail later at interview. After this rule, that is the most dangerous habit, the first filing has to survive a paper review. Clear is not the same as long. Completeness matters. Who, protected ground, timeline, government protection, internal relocation, vague fear of return usually collapses. Entry date, status, and prior applications must corroborate each other. If passport, entry records, and old filings do not match, an officer can find the flaw without seeing you. RFEs may happen. They are not promised for every case. Putting all hope on a later explanation is no longer a safe plan. If it can go into the file now, put it in now. If a preparer wrote your case and you never carefully read it, this is a damage control window. The later you find shells and contradictions, the worse the position. Among Chinese-speaking applicants, multi-hand filings are common. Agent, translator, successive lawyers' files assembled that way break consistency easily. Under this rule, inconsistency costs more. Translation quality matters. Chinese statement, English translation, and form checkboxes must tell one set of facts. Tone made heavier or lighter by translation will be tested in court too. Referral is not the same as losing. The forum changes, so preparation must. Do not walk into court with asylum office habits. An asylum office interview is relatively non-adversarial. Immigration court is adversarial. Charges, calendars, evidence deadlines, and often government counsel. That structure is the process, not a scare tactic. Before a judge you can still pursue defensive asylum, withholding, cat protection, and other relief you qualify for. A judge does not have to rubber stamp USCIS. Referral is not a final loss letter. One more point. A referral or hearing notice is not proof the case is fully docketed in EOIR systems. Check whether your A number appears in public case status. Do not stare only at the envelope. Master calendar and individual hearing are different. Masters often handle procedure. Full testimony and cross-exam usually sit on the individual hearing. Do not treat the master as the only battle, and do not ignore address and representation issues there. After referral, time and money costs can rise. Preparation, appearances, renewals, the government saves an interview slot. Applicants often pick up a heavier process load. Online chaos clusters around work permits and instant deportation. Separate those rumors. Deportation first. Referral starts immigration court process. It is not officers removing you on the spot. No hearing, no order, do not hear tomorrow, you are gone. Clickbait loves turning referral into instant removal. Work permits next. This interim final rule's main text is not rewriting CO8 eligibility itself. Do not merge referral rules and EAD rules into one notice in your head. In practice, check separately. Category, expiration, whether renewal still gets automatic extension against USCIS EAD pages and your approval notice. Do not trust a side comment in a referral video. Some say referral means asylum is over. No, you may still pursue asylum and other relief in court. Outcome turns on evidence, law, and the judge, not the envelope alone. Some say every interview is cancelled. Also, no. Before grant or denial, an interview is still required. What can change is the default pre-referral meeting for some cases. If referral is likely or already here, shift from office Q&A to court proof. Court thinking starts with the evidence chain. Courts weigh chains, witnesses, translations, country conditions, consistent timelines. Memorizing one spoken story while papers conflict will hurt badly in an adversarial room. Evidence and story must be one fact set. Dates on the form in this statement and from witnesses must match or you will be pressed. Court is cross-examination, not a recitation contest. When the referral notice arrives, the first move is not panic forwarding. Check court, date, and a number. Scan and keep every page. Store originals separately. Common master calendar traps, outdated address, no representative, unfiled key applications. If procedure fails, strong merits can still arrive late to a weak position. The government's line cut duplicative review, clear backlog, save interviews for cases that need them, and surface national security and public safety cases faster. Supporters say clearly late or clearly ineligible cases should not occupy interview slots. Understand that narrative. Prepare for the reasonably worst paper read of your file. Critics worry trauma affects memory, translation changes tone, and old preparers omit key. Some one-year exceptions only make sense with medical, status, or psychological context. Paper-only screening can push people who could have explained into a harder forum. For applicants, the useful move is not picking a team online. It is making the file survive cold reading. On action, stop only bookmarking videos. Work the list in order. Step 1. Assemble every page of the original I-589, attachment list, receipts, RFEs, statements, and translations. If you lack originals, chase email, cloud storage, the preparer, or prior counsel. Step 2. Audit the 1-year issue. If you filed late, check whether changed or extraordinary circumstances and reasonable time are written and can be strengthened. Step 3. Rebuild asylum elements. Who, when, where, why. Link to a protected ground, government protection, fill each gap. Step 4. Consistency check. Form, statement, passport, old visas, prior applications, one set of dates and identity facts. If you find a conflict, document it, then get professional risk advice before you fix it casually. Step 5. Update address and contacts. Notices that cannot reach you make everything worse. Do not wait for a crisis to change the address. Step 6. If you already have a referral or hearing notice, verify court, date and check docketing and start court prep now. Do not wait for the next random post. Step 7. Decide whether you need counsel. Adversarial process, deadlines and cross-exam are expensive to learn alone. Not everyone must hire, but high-risk files need professional eyes. If you have not filed yet, a line before filing beats repairing after. If you are still waiting, stop asking only whether the internet sounds scary. Ask whether your file survives a paper read. Last boundary. This video is about the affirmative path. If you are already in removal on a defensive claim, the framework differs. Do not mix the two tracks. Defensive asylum is already before a judge. The default office interview was never on that line. Do not use this affirmative referral rule to explain a case already in removal. One line close. Affirmative asylum is shifting from meet first, then decide to read the file first. If the paper fails, they may not meet you, they may refer you. What truly changed is not only one interview, it is the preparation logic. From fix it later to the first filing must survive written review. The rule is live. The earlier you clean the file, the more control you keep. Read the file first. That is the line to remember. 3 common scenes for matching. Scene 1, filed 3 years after entry. 1 year box almost blank. Statement 2, pages of fear of return. On paper, that profile looks highly referable. Scene 2, a preparer wrote "See personal statement" with no statement attached, and you never carefully read the English form. That is not a morality play, it is a file problem. Stop the damage now. Scene 3, a relatively complete file, filed within a year, clear timeline, backed up evidence. That is not a grant promise. It is less like an automatic paper fail that skips interview into court. Matching scenes is not a verdict. USCIS discretion and your full record still decide. The point is which gap to fix first, not to convict yourself. If you already received a referral, transfer, or hearing notice, switch to emergency handling. Stop binging explainers as the main action. 3 checks first, name and a number, court location and hearing date, full scan of envelope, body, and attachments. Keep originals separate. Then check public immigration court case status for docketing. If the notice arrived but the system is empty, log the timeline and get advice quickly. As a master date approaches, lock representation, interpretation, address, and basic applications first. Do not spend everything memorizing the story if procedure is not standing. If the notice sets evidence deadlines, mark the calendar in red. Courts are harsh on late filings and no-shows, harder to renegotiate than an office reschedule. After referral, many people first ask whether the EAD dies immediately. Do not assume automatic voiding. Check category, expiration, and renewal rules separately from the referral rule. Be realistic about life load, appearances, evidence hunting, interpreters, possible distant courts, time and money, budget that cost. It is closer to reality than policy chat alone. If you move, change phone or change email, update both USCIS and court address channels. Lost mail is one of the most unfair and most common self-inflicted failures. If the file looks thin, prioritize evidence, do not dump unrelated piles. First rebuild hard identity and timeline. Passport pages, entry records, prior receipt, documents that lock dates, stabilize the skeleton, then evidence tied to the persecution claim, medical records, police reports, witness statements, public reporting, organization letters, lifestyle photos. Do not replace elements. Country conditions must serve your story, not a pasted long report. Readers ask how this material supports risk for someone in your situation. Non-English materials need competent translation. Bad translations range from unreadable to unreliable. Do not cut corners there. A short list of easy mistakes this round for self-check. Mistake 1. Keep waiting for an interview letter and never open your own file. Under this rule, the next letter may be a referral notice. Mistake 2. Change what you say online, but not the English file. Officers read the file, not your social media explanation. Mistake 3. Treat referral as total defeat and stop preparing. Referral is not final loss. Quitting preparation is the closest thing to giving up. Mistake 4. Copy someone else's grant story as a template. Matching plots and floating details fail both paper review and cross-exam. Mistake 5. Treat news titles as legal text. Titles say cancelled interviews and instant deportation for clicks. You need the Federal Register and the notice body. One more pass on the 1-year rule. The year usually runs from last arrival, but exceptions are technical. Changed circumstances and extraordinary circumstances are not synonyms, and a one-line excuse is not enough. Changed circumstances often stress new facts that arose later. Extraordinary circumstances more often explain why you could not file earlier. Both need dates and, where possible, proof. Reasonable time is not endless delay. After the exception arises, longer gaps need clearer explanation. Blank timelines are hostile to paper review. Discretion deserves its own. Listen, even if you look eligible on the surface, officers who find you undeserving of a grant may still Am I eligible is not the whole question. Criminal records, fraud concerns, security flags, and facially unreliable materials raise fast referral risk. That is not internet combat. It is what a cold file shows. Back to the opening. The rule is in force. What helps is not collecting 10 more scare titles. It is editing your file as if it will be read when you are not in the room. If you are waiting, start retrieval and self-audit today. If you have not filed, finish 1-year elements and consistency before you file. If already referred, switch to court pace now. Feeds will keep scrolling. Takes will keep fighting. What you control is whether that stack of paper and that set of dates can survive being read. Check judge grant rates with AsylumTracker. This video is based on the Federal Register and public USCIS materials. It is not legal advice. Check your case with a qualified immigration attorney. The rule is already live. Do not follow rumors and do not wait empty-handed. Cleaning the file beats watching 10 more short videos.